Okay, so I hope you are doing well in the scorching heat. You are taking care of yourself, and the corona is back. So make sure that you take care of yourself while you are preparing for your CLAT examination. Don't get sick at this point of time. Mostly the CLAT 2022 aspirants. Otherwise, it would be difficult for you to make up after you get up from your bed. So take care of yourself, guys. We have gathered once again to discuss three important topics. All the three are very, very, very important topic for CLAT 2022, CLAT 2023. The first is the name itself suggests that it is important, as you can see from the last controversy which is happening from the last 20 days regarding the two bill, and then they became an act. And the third issue, that is the Jallianwala Bagh massacre. You must be thinking that ये तो इतना important issue नहीं है, but don't think that, guys. Based on CLAT 2021 experience, Jallianwala Bagh is also an important topic on what they have asked in CLAT 2021. So we will be dealing with this third topic. The first two can be asked either in your legal section or in your current affairs section. Either of the two can be asked in either of the section. Jallianwala Bagh massacre, generally you will be getting either in the mocks of the current affairs section or in the CLAT examination, that also in the current affairs section. So let's start with the first slide and understand the Criminal Procedure Identification Act 2022. So a very controversial issue that is going on from the last 20 days, the Criminal Procedure Identification Act 2022, which has been passed by both houses of the parliament, and it has received the nod of the president. So guys, let's start with an interactive session. Let me know that when a particular bill become an act, till what time it is called a bill, and when it becomes an act. So let me know in the chat box. So the criminal procedure identification bill, which has created a lot of controversy, has been passed, and the most major thing that has been taken into consideration in the bill is that it has enhanced the definition of various things. For example, what all can be measured, who all can be measured, who will measure. So if there is an accused, if there is a convicted person, now what all you can take from that person while he is in jail or even when he is accused. Now who can take those things from a particular accused person or convicted person, and from whom you can take this. All this thing has been enhanced by amending the Identification of Prisoners Act 1920. So this is the first important point that you have to remember. I did not receive any chat box that when a bill becomes an act. Okay, so the Criminal Procedure Identification Act. Okay, now I have got the response. It has repealed the Identification of Prisoners Act 1920, which is very important for your CLAT perspective, current affair perspective. So one, on the receiving the assent by the president, it becomes an act. Very good. So also let me know, guys, how many sessions are there in the parliament. Okay, so there are three sessions in a year, and what is the minimum gap between which the session has to be conducted? Very good, Roshni. Okay, so the act has repealed the Identification of Prisoners Act. You can imagine such a past act, that is 1920, and the amendment has been brought after so many years. The whole Prisoners Act has been now replaced by this act. Now let's understand in the next slide the importance of this Criminal Procedure Identification Act. The first thing that the act has done, guys, is the expansion of the word measurement. So what, whenever a person, whether a person is convicted, whether a person is accused, these are very important for your legal questions also, guys. You can get a passage on the Criminal Procedure Identification Act. It is a very common question that you can get even in your mock, even in your CLAT examination. The word measurement has been expanded in the new act, where in the previous act it was only the fingerprint and the footprint was available. Now the person who is an accused person or the person who is a convicted person, his palm impression, his retina scan, his iris scan, his behavioral attribute, his signature, his handwriting, and any other examination that is mentioned in section 53 of the Code of Criminal Procedure. So you don't have to remember section 53 of the criminal procedure that you will be learning in your NLUs. Section 53, I am just for your knowledge, I am letting you know, section 53 of the Criminal Procedure Code talks about the examination, medical examination of the accused by the police officer, section 53, and section 53A talks about the medical examination of the rape accused. So two sections are there. So the measurement term has been enhanced not only to finger impression and the foot impression, but even biological sample will be taken, iris sample, retina sample, the handwriting of the accused person will be taken, the signature of the accused person or the convicted person will be taken under the new act that has come into force after it received the signature of the president. It is very important to remember the date on which the president signed the Criminal Procedure Identification Act. Search it on the Google and let me know, guys, when the act was signed. I guess it was 2 days before only it was signed by the president. Let me know the date, proper date I want in the chat box. Okay, and section 53, that is the medical examination of the accused. You don't have to remember what is section 53, just for your knowledge. So this is first provision of the bill. Next, move to the next provision. Now we will be comparing the 1920 Act, which has been repealed by this Act, and what is the present provision that has come. Okay, so under the 1920 Act, first of all, let's understand from whom the measurement can be taken. In the last slide, we discussed what all measurement will be taken. Now we have to understand from whom the measurement can be taken. So in the previous Act, that is 1920 Act, it was that any person who is convicted or arrested for an offence which is punishable with imprisonment, that also rigorous imprisonment of 1 year or more. So guys, if tomorrow Kasturi is giving a mock of CL or Ankit is giving a mock of legal age and you are getting a question that according to the previous act, comma, the facts are as follows. A person X was convicted of imprisonment of 1 year, simple imprisonment of 1 year, whether he will be liable for the measurement or not. Most of the student will be marking that he will be liable for the measurement, but guys, keep it in mind that it is a rigorous imprisonment. So under the 1920 Act, the person who was convicted of an offence for more than 1 year imprisonment, but that should be a rigorous imprisonment. This is very important for your legal passages. This type of question you make mistake generally, so read the word very carefully. It should be a rigorous imprisonment. On them from them the measurement can be taken by whom. It was in the 1920 Act, it was only the magistrate. This is very important. It was only the magistrate who was empowered to collect the measurement from the arrested person. So 2 points you have to understand. In the previous slide we discussed what all measurement has been enhanced. Under the 1920 Act, the thing was a person convicted or arrested for imprisonment, rigorous imprisonment of more than 1 year. Only that from that person you can take the measurement, and it was only the magistrate. Okay, you understand who is a magistrate? There is magistrate of first class, second class. So it was only the magistrate who was empowered to collect the measurement from the arrested person. Now what has the changes that has been made in the current Criminal Procedure Identification Act, that is important. In the present act, under the clause 3 of the when it was bill, now it has become an act. The police officer or prisoner officer. So you can understand what a vast change has been done there. From the magistrate, you can understand magistrate is a judicial person. He is having such an authority over the district. Directly from the magistrate, it is to the police officer or the prison officer, the whole power has been given. Now the important thing is the police officer here should be the officer in charge of the police station and not below the rank of head constable, and the prison officer should be not below the rank of head warden. So any prison officer cannot take measurement from you. So if tomorrow a person X has been accused or convicted in any offense, then any of the prisoner officer cannot take the measurement from him. It is only the head warden. So no one should be below the rank of head warden, and in case of police officer, it should be the officer in charge of police station, not below the rank of head constable. These are the words that you generally do mistake while solving the legal passage, guys. Most probably in 90% case, I feel that this would be a legal passage, not a current affair passage. Mostly it will be a legal passage that is having a high probability of coming in your mock and even in your Clat examination. So you have to understand from the magistrate, now the police officer or the prison officer has been given the power. The difference you have to note it down while even solving the passage in your legal section. So it should be not below the rank of head constable, not below the rank of head warden. That is the clause 3 which is empowered. Now we have to understand that under the present act, okay, from whom the measurement can be taken, that will be getting know from the next slide. Because in the 1920 it was only a person who was having it was only a person who was having a rigorous imprisonment of more than 1 year. I got a chat. According to this 1920 Act, is it only the convict or even the accused can be asked for the measurement? Only the who has been convicted, who has been convicted in a case having an imprisonment of more than 1 year rigorous imprisonment. Okay, now under the clause 3 of the act, that is the present act we are talking about, any person who has been convicted for an offence will be taken into consideration. Any person who is ordered to give security under section 117, 107, 8, 9 and 10 of the CRPC. You don't have to remember the section for your knowledge. You will be learning the section in your NLUs. So section 117 and 107, 8, 9, 10 talks about the for the security of a society, for the maintaining of peace, a person can be asked to pay deposits. That is the section. So first is any person convicted of an offence will be coming under the section clause 3 of the new act. Any person who has been ordered to give security for good behavior under section 117. Now the major, the vast change that has been brought under the act is any person arrested with respect to offence punishable by law. So whatever is the offence, if it is an offence even of having a punishment of 1 month, even if it is having a punishment of 1 year or 10 year life, whatever it is, that is not the issue. The issue is any person who is arrested with respect to any offence which is punishable by law. So against the 1920 Act, which was having rigorous imprisonment of 1 month, here we have a person arrested with respect to any offence. So not only the convicted, which was already there, here it has been changed. This is a drastic change that has been brought. There is no limit of imprisonment. Even imprisonment of 1 month, people can be asked to give measurement. And then any person detained under preventive detention law. So which article of the Indian Constitution talks about preventive detention, guys? Let me know. Okay, now so we have clause 3. First of all, clause 3 talks that it is not only the magistrate but even the police officer or the police warden. Okay, it is not only the police officer but even the police warden who can take the sample or who can take the measurement from the convicted person. Very good, Mahima. Okay, what about other guys? Which yeah, very good, Roshni and all. So it is article 22 which talks about the preventive detention law, preventive detention in the constitution. Other we have the preventive detention act separately, but in the constitution it is article 22. So now the apart from the magistrate, the police officer and the head warden has been given the power to take the measurement. Now another thing that has been brought and which is in controversy is any person, that is the convicted person, accused person, with a simple imprisonment, 1 month imprisonment, he can be compelled to give the measurement under the new act. So this is a very big controversy that is going on in our country as of now. You must have seen in the Twitter, Facebook, on the news channel, everywhere the criminal identification bill is there, act is there. So the clause 5 of the bill, it empowers the magistrate to compel any person if he is satisfied that it is expedient to do so for any investigation. So it is fully on the discretion of the magistrate. If you are getting any legal question tomorrow in your mock, legal age, career launcher, whatever it is, you will be getting that it is at the discretion of the magistrate. Directly he will be getting it is at his discretion. If he think that it will be helping in the investigation, he can ask any person, he can compel any person to give the measurement, but there is a term and condition that will be knowing. Next slide. Till this slide it is clear to everyone, guys? Previous slide, everyone, it is clear? So from what all measurement are there, from whom the measurement can be taken and who can take the measurement, all we have already discussed. Now let's move to the next slide. Now the questions, the slide start with, can I be compelled to give my measurement? So as I have told you in the previous slide, clause 5 of the bill of the act, now it has become an act, it has empowered the magistrate to compel any person to give the measurement. Now here comes the topic consent. So whether when I am being compelled to give my measurement, it goes against my consent, that is article 20 clause 3. Can anybody tell me what is article 20 clause 3 of the Indian Constitution? Just the short term I want, not the whole sentence of the article. What is article 20 clause 3? So it tells that it goes against article 20 clause 3 of the Indian Constitution. Very good, Manas. It goes against article 20 clause 3 of the Indian Constitution, that is the protection against self incrimination. I cannot be compelled. Even in the CRPC, in the various sections of the CRPC, it is mentioned that a accused person or a person who is convicted, he cannot be forced to give any statement which goes against him or to do any sample or to give any sample which goes against him. Now, there is a term and condition to this compellment by the magistrate, that in the case of biological sample, it will be only in case of a person who has been arrested or convicted for an offence against woman, child, or an offence punishable with more than 7 years of imprisonment. So, if you are committing a crime against woman, if you are committing a crime against child, or if you are committing a crime which is having an offence punishable with more than 7 years, for example, Section 307 of the IPC, attempt to murder. So, the punishment is 10 years to life imprisonment. Okay, if you are committing murder, if you are committing rape, whatever it is, so if the punishment is more than 7 years, if it is a grave offense, in that case you will not be obliged to give the biological sample. What is biological sample? The DNA test, narco test, and all those tests are the biological sample. So in those tests, the consent of the accused person or the convicted person is required. Now, let's so these are the person who can be compelled to give the measurement, and only in case of woman, child, and offense punishable with 7 year more, in that case you will be pressurized, you will not be pressurized, your consent is required for the biological sample. Next slide. Now, another important aspect of the new Criminal Identification Act is for how long the measurement can be stored. So, the National Crime Record Bureau, that is NCRB, where is the headquarter, guys? Let me know the headquarter of NCRB and who is the current chairman. So, for 75 years, the measurement of the person can be retained for 75 years. However, it has been mentioned that a person who has been discharged, acquitted, released without trial after exhausting all the legal remedies, he will be their record will be deleted, their record will be destroyed. So for 75 years, the measurement will be collected, all the data will be collected by the National Crime Record Bureau, and if the person has been only if the person has been discharged, acquitted by the court, released without trial, and after existing all the legal remedy, the person, the all the record that has been collected will be destroyed. Okay. Now, so New Delhi, who is the chairman, guys, of the NCRB? Next slide. Now let's discuss what are the problem of the act, why the act is in controversy. So this we discuss what are the measurement that can be taken, from whom the measurement can be taken, by whom it can be taken, from whom it can be taken, for how long it can be kept, for 75 years. Okay, search, guys, the chairman or what president, whatever it is of the NCRB, and let me know. Now, what are the problem with the act? Let's understand. This is important for you to answer your legal passages. First is it fails Article 14 of the Constitution. So, according to the criminal expert, according to them, they have for the biological sample, the discrimination has been made only in cases of women and woman, child, and then for the case in which the offense is punishable with more than 7 years. So one of the allegation on the act is that it fails the test of Article 14 because there is a discrimination on the act for allowing the biological sample in other cases but not allowing in the cases where it is for the woman, child, or where it is for the offense punishable with more than 7 years. Okay. Next is very important, that is Article 20 clause 3 of the Constitution. That's, I guess it was someone mentioned in the chat box also very rightly, Manas. Yeah, very good. So they have told the criminal expert, according to criminal expert, the Criminal Identification Act, it is against Article 20 clause 3 because a person cannot be compelled to be witness against himself. Okay, but just for your knowledge, guys, let's go back to two cases that is mentioned in the slide. First is the state of Bombay versus Kathukalu. In this case, what happened? It is mentioned Kathukali, not Kathukalu. It is Kathukali. State of Bombay versus Kathukali. In this case, it was great. The Supreme Court held that in taking all the samples apart from the biological samples, that is your footprint, fingerprint, and all other thing, it is not a self-incrimination case. Okay, the Supreme Court in the case of State of Bombay versus Kathukali has clearly held that collecting such sample like footprint, fingerprint, and all those samples does not goes against Article 20 clause 3 of the Indian Constitution. Another case is Selvi versus State of Karnataka. Now this case is what, in this case the Supreme Court has held in the Selvi versus State of Karnataka that the biological sample like narco analysis test, DNA profiling test, it should not be done against the consent of the accused person or any person. go back to the act and remember, guys, the act clearly mentioned that in case of biological sample which include the DNA test, DNA profiling, narco test, there will be consent of the person. They cannot be compelled in cases of women case offense with more than 7 years. So these are the two cases you have to remember. State of Bombay, where it was held that the samples like footprint, fingerprint, and other samples, they do not come under the Article 20 Clause 3 of the Indian Constitution. And Selvi versus State of Karnataka, in which it was held that biological samples should not be taken against the consent of the person. Now another is the violation of Article 21. So the law should be fair and reasonable. There should be no violation of the privacy of the people. This all were declared in the case of K.S. Puttaswamy, the famous case of K.S. Puttaswamy versus Union of India. According to the criminal expert, the criminal identification bill goes against Article 21 of the Indian Constitution. That is, your right to privacy is being violated in various instances, because there should be a proportionality. You must remember the term proportionality, nexus. These are very important term for a law student. So the scope of the term measurement has been expanded, and it not only includes physical behavioral attribute but also biological sample. So according to the criminal experts, there is a violation of article 21, that is right to privacy. Next slide. Now, another very important issue is that the power that has been conferred to the warden of the prison warden and then to the police officer, this give a very vast power, because the magistrate, there is a very vast difference between a magistrate and a police officer, whether it is a head constable or officer in charge of the police station. So they can use this data for wrong purpose. Okay, there can be wrong purpose that can be used, the data can be used for the wrong purpose, and therefore there is a allegation that the power that has been conferred to the police officer or to the prison warden, that should not have been done, and the time period of 75 year is just an arbitrary according to the criminal expert, because according to them there is no reason for keeping the record of the people of those people for 75 years. So I understand, guys, if a person is committing a crime at the age of 25, you are keeping the record for 75 years. What you will be doing for the record for 75 years? If the person survive only for 60 up to the age of 60 year only, that is another thing. But that is the allegation that has been put on the act, that keeping the record for such a long data by the NCRB is of no use. There is no reason which is given by the central government, and it is just an arbitrary act. So this is all about the Criminal Procedure Identification Act. Let's have a quick recap in the chat box. First of all, tell me that previous slide finish. Let's have a quick recap in the chat box that the Criminal Procedure Identification Act has replaced which act? Which act has been replaced by the Criminal Procedure Identification Act? After which, tell me that the act has been told to be against which article of the Indian Constitution which talks about self-incrimination? Okay, so I have got the response. What about others? Huh. So it talks about Article 20 Clause 3, which goes against the self-incrimination. What is the duration for which the record of the person will be kept with the NCRB? Okay. Which article of the Indian Constitution talks about preventive detention? Apart from the magistrate, who all other people has been given the power to take the measurement? Apart from the magistrate, who all have been given the power to take the measurement? And in the previous act, it was imprisonment of 1 year or more. Now, in the current act, it is imprisonment of more than 7 years for taking measurement, whether the statement is true or false. Okay, police head constable and above prison head warden and above. Very good. So I am repeating the sentence. In the previous act, a person who has been convicted or accused of an offence of more than 1 year rigorous imprisonment, he was liable to give measurement. Okay. In the present act, that is the new act which has come into force, any person who is having an imprisonment of more than 7 years will be asked to give the measurement, whether the statement is true or false. Mm-hmm. What about others? Okay, one is true, one is false. What about Ushav, Manas, Vrinda? Okay, false. Not above 7 years. Any person who is accused of any offense will be liable in this case. Okay. Now let's start with another important topic, that is the Delhi Municipal Corporation Amendment Act 2022. So who is the person, guys? Previous slide. Who is the person, guys? This person who is standing. Okay, sir. Okay. 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 Amit Shah ji. Okay. He is the Home Minister of India. Apart from this, which ministry he is holding? Apart from Home Minister, which new ministry which has been formed comes under him? Okay. Which is the new ministry which has been formed by the central government recently after the recent cabinet shuffle? Also tell me that there it is written Pitasin Up Sabhapati. So who is the present chairman of the Rajya Sabha? Who is the present chairman of the Rajya Sabha, and generally who is the chairman of Rajya Sabha? Venkaya Naidu. Okay, very good. So the current chair is Venkaya Naidu, and generally who is the person who is the chair of the Rajya Sabha? Vice President. Okay, very good. Uh, okay, guys, good. And who is the person beside Amit Shah? Sitting very sadly. Okay, very good. Let's start with the discussion. So, Delhi Municipal Corporation Amendment Act 2022. Next slide. Has been passed by both houses of the parliament, that is Lok Sabha, Rajya Sabha, and it has also received the nod of the president. Let's start what is new about the bill. Before that, let me tell me, guys, a money bill can be introduced only in Rajya Sabha. Whether the statement is true or false? False. False. Okay. So let's talk about this Delhi Municipal Corporation Amendment Act 2022. What is the main thing that the act has done? It has merged the three municipal corporation of Delhi, that is the north, south, east. Don't mention west because there are only three: north, south, east. Okay, there are the three municipal corporation, that is the north municipal corporation, south municipal corporation, east municipal corporation. They all have been merged to a single municipal corporation for the better efficiency, for the better performance of all the municipal corporation. Next slide. So the Delhi Municipal Corporation Amendment Act in 2011, after the recommendation of various committee of the state government, of the various law commission report, and then finally the committee on the by the central government, they decided that the Municipal Corporation of Delhi will be trifurcated into three, that is three municipal corporation for the better efficiency. Okay, and then the Delhi Municipal Corporation Amendment Bill in December 2011 was passed. The year is very important, guys, and it was divided into three, that is north, south, and east Delhi municipal body, having 104 ward for the north and south and 64 ward to the Delhi. Now this is having a probability 50-50 in both, in your current affair and legal section. Okay, having a probability of both, in it can come either in your current affair section or in your legal section. So the 2011 Act, it trifurcated into three, with 104 for North and South Municipal Corporation and 64 for the East Delhi Municipal Corporation. Okay, guys, next slide. Now, according to the central government, when there were three municipal corporation, okay, there were multiple problem. For example, one of the problem was the three municipal corporation, they were not divided according to the territory. The territorial distribution was not even. Okay, there was uneven territorial distribution. The resources were there were gap of resources among the three corporation. There were difficulty in funding of the different, all the safai karamchari and all the sweepers. The property tax that were given from the houses of all the, or the building of the municipal corporation, were different, as a result of which it was difficult for the municipal corporation to function efficiently. Remember, in 2011 it was trifurcated into three so that it can efficiently work. Again, it has been summed up into a one municipal corporation so that it can work efficiently. So these are the problem which, according to the central government, that the current scenario was facing. There were difficulty in facing in doing the timely payment of the salary because of the uneven distribution of property taxes between all the different bodies. So they have brought a one. There will be only one municipal corporation in Delhi. Next slide. Now, the bill has replaced the three municipal corporation, and there will be only one corporation which will be known as Municipal Corporation of Delhi. This is very important. The term, it will be called the Municipal Corporation of Delhi, and now the number of seat in the new corporation has been fixed to not to be more than 250, and then it will be the discretion of the guys. It will be the discretion of whom? Let me know how much you have read the act. The act states that the total number of seats in the new corporation, it should not be more than 250. However, it would be at the discretion of whom, guys? Central government or the Delhi government? And then the act talks about there should be e-governance, so that it would be an accountable government. There should be transparency in the administration. There should be a better administration that should work. And so the act talks about that the municipal corporation should work on the basis of e-governance. I have not got the response, guys. The bill states that the total number of seats in the new corporation should not be more than 250. It will be at the discretion of the central government or the state government. That is the state government here is the and city of Delhi. Anyone? Just guess. Ankit, Ushav, anyone? Center. Okay, good. Yeah, the guess is right. It will be at the discretion of the center, that is the parliament. So it will be the parliament or the central government which will decide whether we have to extend the number of seat or not in the municipal corporation. So these are the three. The bill has replaced the three municipal corporation under one. The number of seat has been fixed as of now to 250, and there will be e-governance for accountability and transparency. Next slide. Now let's understand what is municipal corporation. So municipal corporation works as a local government in those areas mainly in which it is a metropolitan city. Metropolitan city is something a city which is having a population of more than 1 million population. Okay, so you have to remember from your current affair perspectives that the metropolitan city is something which is having a population of more than 1 million people, and the first municipal corporation of India was set up in Madras in 1688, followed by the Municipal Corporation of Bombay and Calcutta in 1726, which is very important. So I told that this topic is 50-50 probability of coming in even in your legal passage, even in your current affair passage. Mostly it can come in your current affair passage only. So you have to remember the first three municipal corporation, that is of Madras 1688, and then the Bombay and Calcutta, that is 1726. And municipal corporation is a local government which is for the development of any metropolitan city which is having, and metropolitan city means a city which is having a population of more than 1 million people. The other name of municipal corporation like Nagar Palika, Nagar Nigam, and all these things are mentioned in the are mentioned in the slide. Now let's move to the next slide and understand the constitutional provision of the municipal corporation. So if we discuss, the municipal corporation is nowhere specifically described in the Indian constitution that there will be an establishment of Indian constitution, but we have the 74th Amendment Act which inserted part 9A of the Indian constitution and told that for the administration of municipality, for the local government, we will be having a municipality which will be at the three level, that is Nagar Panchayat, Municipal Council, and Municipal Corporation. 74th constitutional amendment talks about municipality. Can anybody let me know which amendment act talks about the panchayat? So article, very good Mahima. So article 40 of the directive principle of state policy talks about that there should be local self government in India, of which we have 73rd amendment which talked about panchayat, and 74th amendment talked about municipality, and the part 9A was inserted by the 74th amendment which talks about the Nagar Panchayat, the municipal council, and municipal corporation. We are discussing the municipal corporation part here, that is of Delhi. Okay guys, is till this it is clear to everyone what you have to remember from your Clat perspective, that which act has been amendment, what were the previous provision, what is the new provision, what is the total number of seat that has been fixed in the new municipal corporation, and the constitutional provision of the municipal corporation having 74th amendment, and you have to remember article 40 which talks about the local government. Next slide. Now, what is the contention of the central government? The two important article that is mentioned here. The central government state that we have article 239 AA, okay, which gives the special status to the Delhi. So Delhi is a union territory, the national capital territory of Delhi, as you know, NCT of Delhi. Okay, so the special status has been given to Delhi under article 239 AA, in which the Home Ministry has told that under article 239 AA clause 3 clause B, it will be the central government who will be making the law for the purpose of ward, for the extension of ward, for the reservation of seat in the municipal corporation. So after the new amendment, all the power has been given to the parliament. Before it was the three municipal corporation. Now we are having only one municipal corporation, that will be called the Municipal Corporation of Delhi. And under article 239 clause A, clause 3 clause B, all the power has now been given to the parliament for making the law related to the number of ward, the extent of each ward, the reservation of seat for the corporation. That means the parliament means the central government. And as it is mentioned in the bold, and what Ankit has also mentioned in the chat box, that the number of seat in the councillor of the municipal corporation will be decided now by the central government. As of now, they have fixed it to 250. Next slide. So article 239 clause AA, which gives the special power to Delhi, that is NCT of Delhi, it was inserted by 69th Amendment Act. Okay, before that, let me know in the chat box that who is having the law and order power in the NCT of Delhi, whether it is the Delhi government or whether it is the central government who take care of the law and order of the Delhi. Law and order, public peace comes under which, whether it is the Delhi government or whether it is the central government. So the 69th, yeah, very good Sushant, very good Rustav. Now those who were going to give the correct answers, they will not give. Police, in the NCT of Delhi, the police come under the Home Ministry, that is central government. Law and order of Delhi comes under central government. What are the other three? Search it and let me know before the session end. Ankit, Utsav, anyone? What are the three things that come under the central government or the Home Ministry in spite of Delhi being a union territory? So the 69th Amendment Act inserted article 239 clause AA of the Indian Constitution, which state that Delhi will be called the national capital territory of Delhi, which will be having a lieutenant governor like other union territory. And can anybody tell me who is the lieutenant governor of Delhi? Guys, this is the way you have to make notes. You don't have to only remember the Delhi Municipal Corporation Act. You have to connect the dots from 69th Amendment. When was the 69th Amendment introduced? Who is the Lieutenant Governor of Delhi? Who is having law and order? Who is having public peace, public order under the Delhi? You have to remember all this thing. Anil Bajal, very good, Manas. So the Lieutenant Governor of Delhi is, yeah, you are correct, Manas, that it is Anil Bajal is the current Lieutenant Governor. Also, let me know, guys, what are the things in Delhi that comes under the central government? It is very easy. Just search on the Google, you will be getting on the first page only. What are the things that come under the central government? And Delhi Police. Okay, Delhi Police comes under the central government. What are the other things? There are three things that is specifically mentioned. I want those three things. So this is Article 239A, which is talks. This or the only thing that you have to remember for the Delhi Municipal Corporation Act, that is it has replaced which act? The three ward, not the west, it is only north, south and east. What were the total number of ward in each before this amendment? Okay, under which article of the Indian Constitution the central government is making law now? What will be the total number of councillor as of now? Who will be having the power for the same? And then you have to connect the dot from 69 amendment. It is very important amendment for NCT of Delhi. You have to know the lieutenant governor and the three things that any one of you have not able to tell me now as of now. Land police. Okay, Ankit, you are very good. Land police, very good. And don't know. Okay, I must say you tried your best. That is correct, Ankit. Land police. Okay, so the land police and one more thing is there. So land police and one more thing is there. Search it and let me know, guys. So these three things come under the central government, that is the Home Ministry mostly. Okay, so two important topic we have covered. Next slide. Jallianwala Bagh massacre. So guys, you must be thinking ये topic important नहीं है, as I've told you in the starting of the session. But I remember in my time when I went to give a mock of carrier launcher, so I was also having the same gut feeling that अरे Jallianwala Bagh massacre में क्या ही पूछेंगे क्लैट वाले. But in continuous two mock of carrier launcher and in one mock of another coaching, I don't remember, I got the question on Jallianwala Bagh. I could not attempt all the 5 questions I left. Okay, sir, I thought that you must know, you should not make the mistake which I made in my CLAT preparation. Jallianwala Bagh massacre, guys, a very sadful event of our history. So let's start with the first slide of the topic. So the Prime Minister has paid tribute, this is very common thing, to the Jallianwala Bagh massacre 1919. So the date is very important, 13th April 1919. Okay, the date is very important of the Jallianwala Bagh massacre, that is 13th April 1919, when lot of people were fired by the General Dyer. So the 13th April 2022 marks the 103rd year of the Jallianwala Bagh incident. Guys, let me know, it is very now easy for calculate that when was the 100th year of the incident celebrated. So you can be asked in your current affairs section that this is 103rd, this is 103rd, very good. So this is 103rd, which was the 100 year, you have to remember. You will not be asked directly, that it will not be mentioned in the passage that this was the 103rd year, and you will be asked that when was the 100th year of the incident was celebrated. So 13th April 2022 marked the 103rd year. Now a very controversial point that is definite if you are getting a Jallianwala Bagh question in your passage, that which of the following event does the Gujarat government talked in consideration with the Jallianwala Bagh massacre, that is the Pal Dhadav killing. So the Gujarat government has went to a step further and they marked the 100 year of the Pal Dhadav killing, which called it a massacre which is bigger than the Jallianwala Bagh. Remember the Gujarat riot, Godhra Kand 2002, that is the period in which this Pal Dhadav killing was taken place. So they have told that this massacre is bigger than Jallianwala Bagh. Why I have mentioned this? Because you have to remember this. The CLAT will ask you that which of the following event did the Gujarat government discuss, or something like this. Frame the question. That is the Pal Dhadav killing. Okay. Next slide. So what is the Jallianwala Bagh massacre? Jallianwala Bagh massacre is the gruesome attack on the million of people, women and children in the Jallianwala Bagh, that is the public garden in Amritsar, on 13th April 1919, when the people were peacefully demonstrating against the Rowlatt Act 1919. So it was the day of the Baisakhi festival of the people, and they gathered peacefully and they were demonstrating against the Rowlatt Act 1919, which is very important. In that, General Dyer came with his troop and attacked the people. He did not saw whether it is a woman, whether it is a child. A million of people lost their life in this gruesome attack of 13th April 2022. Apart from this two historical thing, you have to remember the Lieutenant Governor of Punjab that time, that was Michael O'Dwyer, and the Lord Chelmsford was the Indian Viceroy. Guys, don't feel that these are not important for a CLAT examination, or even if you're mock. If you're getting a passage on Jallianwala Bagh, you will be getting only this all this question that is mentioned in the slide. So you have to remember the person who killed was General Dyer. It was on the advice of Michael O'Dwyer, who was the Lieutenant Governor of Punjab, and then you have Indian Viceroy, that is Lord Chelmsford. Is it clear to everyone? Vaishali is not active today. Vrinda is not active. Other people, Ankit, Ushal, Susant, Aviraj, everyone clear, guys? Till here? Yeah. So these are the things that you have to remember, that the attack of Jallianwala Bagh massacre was against the Rowlatt Act. Okay, Rowlatt Act 1919, that we will be discussing next. That what is the Rowlatt Act. This all thing you have to remember from this slide. Next. Now, these are also important point that is generally asked. Against the Jallianwala Bagh gruesome attack, Rabindranath Tagore ji, he gave up his knighthood, and Gandhi ji, who was given the title of Kesar-i-Hind, he also returned back the title. Even even if you see the return of title thing goes on when there is any incident or something happen, the Padma awardees, they return their award. Okay, very good, no problem. They can return. There is freedom for everything. Similarly, Rabindranath Tagore, he gave up his knighthood, and Gandhiji relinquished his title, that is Keshari-i-Hind. So you don't have to remember the for what he has returned, but you have to remember the two term, that is his knighthood and Keshari-i-Hind. It is very important if a passage comes, that which was the award that Gandhiji returned, that is the title, that is Keshari-i-Hind. Now Michael O'Dwyer. Who was Michael O'Dwyer, guys? And who was the Indian viceroy at that time. So Michael Lord Dyer, on advice of whom General Dyer killed the people, yeah, in the LG of Punjab. So Michael O'Dyer was assassinated by Udham Singh. Okay. Now you will be feeling, guys, that iska kya kaam hai. Don't feel that you will be getting question. Understand now. When you will be having a passage on Jallianwala Bagh, then you will be remembering all these things. So Michael O'Dyer, who was the Lieutenant Governor of Punjab, he was assassinated by Udham Singh. Okay. So General Dyer did all the thing. Advice किसका था? Lieutenant Governor of Punjab, that is Michael O'Dyer. तो उसी को मार दिया जाए. Okay, Udham Singh. Next slide. Now we have to understand in this slide that what is the Rowlatt Act, because all the incident that happened, it was in against the Rowlatt Act only, guys. Okay, all the incident that has happened, it was against the Rowlatt Act only, the Rowlatt Act. So everyone knows that Rowlatt Act, Rowlatt Act. Even if you ask a class 10 student, they will know Rowlatt Act. The official name of Rowlatt Act is Anarchical and Revolutionary Crime Act of 1919, guys. Very important. Okay, so if I would I would not get the opportunity to set the paper, but if I would get the set a paper of your Lighting Dream All India mock, that is going to happen very soon. Get yourself ready in the next week. So I will be giving this question, that what is the name of or against which act the Jallianwala Bagh massacre happened. I will not mention in the exam in the what is called it is option Rowlatt Act. I will be mentioning Anarchical and Revolutionary Crime Act 1919, because Rowlatt Act to everyone know, every 70,000 plus or 70,000 minus Clat aspirant that will be giving Clat examination, they know you have to remember Anarchical and Revolutionary Crime Act 1919, which was passed in 1919, which gave the authority to the British government to arrest any person without any kind of warrant, and they can be kept arrested without any trial for 2 years. Anybody let me know how much you are aware of with your crime. When any person is arrested, okay, listen the question very carefully. When any person is arrested, so for example tomorrow X person is arrested by the police, within how much time he has to be presented before the magistrate? Let me know. Within 24 hours. Very good. So Ankit has started typing the answer before I have completed my question. I know. So the Rowlatt Act, very good, all of you guys, good. So the Rowlatt Act gave the power that person who has been arrested under the Rowlatt Act, he will be kept arrested for 2 hours without any trial. There will be no warrant. So what is warrant means, guys, here that there are two type of offense. Remember this. Don't think that it is out of syllabus or not in your Clat examination. If you get a passage on crime, you can get thing. There are two type of offense. One is cognizable offense and other is non-cognizable offense. Anybody who is aware of the same, I guess Utsav must be aware. I will be telling it. Let me know if anyone is aware. So the Rowlatt Act, it places a lot of restriction on the press, and the act was passed on the recommendation of a committee which was chaired by Sidney Rowlatt. The name of Sidney Rowlatt is again very important. So Rowlatt Act, you have to remember the original name of the act. The person can be arrested for 2 years without any trial for 2 years, no warrant, and the name of Sidney Rowlatt is very important. That is on whose recommendation the Rowlatt Act was passed. So I talked about cognizable and non-cognizable offense. First I have received Vrinda. Cognizable is something without a warrant and non-cognizable is with the warrant. Okay. Cognizable offense are those offense, guys. In cognizable offense, person can be arrested without warrant, and in non-cognizable offense, person can be a warrant if required. Very good, sir. So for the people who don't know, I know most of you must be knowing this, but still I'm repeating. Cognizable offense are those offense in which the police do not require a warrant. So cognizable offense are such offense which are very grave in nature. For example, if tomorrow a person X commit offense of murder, rape, a very offense which is having a punishment of 2 years or more, is a cognizable offense in which the magistrate, very good, the magistrate will, the police officer does not require the order from the magistrate. But if it is a very common offense, not a grave offense, okay, which is having a punishment of less than 2 years, okay, it is not a grave offense. In that, it is compulsory for the police officer to take a order from the magistrate. So until and unless the magistrate issue a warrant, the person cannot, the police officer cannot arrest the person. Under article 7, under section 70 and 71 of the CRPC, the warrant is issued by the, it talks about the issue of the warrant by the magistrate. So the warrant will be issued definitely in cognizable cases. Sorry, in non-cognizable cases. Okay, but in cognizable cases there is no requirement of any warrant. The person can be arrested without any kind of warrant, because those offences are grave offense like murder, rape, and such offense which is having imprisonment of more than 2 years. You can directly say which is a grave offense. Okay, bailable and non-bailable also, you know, bailable offense is one in which bail is a matter of right. Okay, that is section 2A of the CRPC talks about bailable offense and non-bailable offense defined. And non-bailable offense is one, it does not means that you will not be given the bail. Non-bailable offense is an offense in which it is at the discretion of the magistrate. So if the magistrate feels that tomorrow if I give bail to X, he will be coming to my court, he will not be an absconder, he will not be diluting the evidence, then only the magistrate will give the bail. But in case of bailable offense, it is a matter of right for the accused person to get a bail. Okay, and non-bailable offense, you cannot get the bail as a matter of right. It is the discretion of the magistrate who will be granting you the bail. Okay, so this is cognizable, non-cognizable, bailable and non-bailable offense, that is different sections of the CRPC. But you have to remember at least this much: what is cognizable, what is non-cognizable, what is bailable, what is non-bailable. So even in non-bailable you will be getting warrant, you will be getting bail, but that is a discretion of the magistrate. Okay, now Rowlatt Act is done. Next slide. Okay, now another thing you have to remember: on 6th of April, Gandhiji started a satyagraha, nationwide satyagraha, which was called the Rowlatt Act. So you have to remember what is Rowlatt. Either you have to remember Rowlatt satyagraha or the date on which it was started. And the last point you have to remember from Jallianwala Bagh massacre, guys, you have to remember the name of the two leaders, that is Satyapal and Saifuddin Kichliu, who was arrested. So these are the questions that I got in my All India mock, which was organized by various coaching. The same question I also received, so I have mentioned them specifically: Satyapal and Saifuddin Kichliu. Have a quick revision, guys, in the chat box. First of all, tell me what is the date on which the Jallianwala Bagh massacre was, the event was there? 13th April 1919. Okay. The year 2020 mark which year? Which year of Jallianwala Bagh massacre? 103rd. I have got 100. I have got 103, 101, 101, 101. Is it 101, guys? Or whether it is 103rd? Previous slide, Kanishk. 103rd. Very good, Ustav. No, yeah, this one. It is 103rd. Okay. Then tell me, under the Rowlatt Act, a person can be arrested for 3 years without trial, whether the statement is true or false. Under the Rowlatt Act, a person can be arrested for 3 years without trial for 2 years. Very good, Maima, Ankit. Good going, guys. Okay. Then, apart from this, who was the Viceroy of India at that time when the Jallianwala Bagh massacre incident happened? And who was the person who ordered who did the brutal act? Not who ordered, who did the brutal act? General Dyer, Lord Chelmsford, General Dyer. Okay, very good. Okay, next slide, Ganesh. Move to the wait at this slide. Okay, and no, the next slide. Yeah, and who are the two Congress person who was arrested? Ganesh, next slide. Yeah, who are the two Congress person who was arrested in the Rowlatt Act case? What was the title that Mahatma Gandhi gave up, and what did Rabindranath Tagore give up? Satyapal, Saifuddin, very good. Mahima, Kasturi, everyone. Kaisar-e Hind, and what was the Rabindranath Tagore gave up? Knighthood. Okay, very good, guys.